Greetings and welcome to this week's edition of Smart Counsel for Lunch. I'm Suzanne Sayward, a partner at the Dedham, Massachusetts law firm of Samuel, Sayward, and Baylor, where we concentrate our practice in the areas of estate planning, elder law, estate and trust administration, and probate. Today, I'm going to talk a little bit about life estates. A life estate is a common planning tool for parents to preserve the value of their real estate against a Medicaid lien or spend down for long-term care costs. It's used primarily when the parent's objective is to make sure the value of the home or other real estate passes to their children when they pass away. It works like this. Mom has lived in her home for decades. She wants to pass on the value of that home to her children. So she executes a deed conveying the property to her 3 children. And on the deed states, I reserve the right to use and occupy the property during my lifetime. So that reservation of that life estate does a couple of things for mom. One, it protects the mom's right to live in the property in case the children turn evil and decide they want to try to sell it out from under her. They wouldn't be able to do that. It also provides a good tax benefit for the children because so long as mom continues to have that life estate during her lifetime, that is, the property is not sold during mom's lifetime, then the property gets what's called a stepped up basis for tax purposes, which is very advantageous for the children when the home is sold after mom passes away. But there are some downsides to the use of a simple life estate. Primarily, it subjects the property to children's potential creditors. While mom is worried about long-term care costs, the children have a lot of other potential troubles, right? They could get divorced or sued or have a failed business or a tax lien, file bankruptcy, get in a car crash. So if any of those bad things happen to one of the children who now is an owner of mom's property, then the property can be subject to a lien by those creditors. In addition, if the property is sold during mom's lifetime, say she decides she doesn't want to live there anymore and the children agree and the property is sold, then mom would not be able to exclude 100% of that $250,000 capital gain exclusion that everyone gets when they sell a primary residence in which they have lived and which they have owned for 2 out of the 5 years prior to the sale. Although mom has lived there, she has not owned it. She only owns the life estate. So a lot of these issues can be addressed by using an irrevocable trust to own the property rather than conveying it to the children. This protects the value of the property for the benefit of the children, just like a life estate, but it also protects the property from the claims of the children's children's creditors. It also ensures that if the property is sold during mom's lifetime, that full $250,000 capital gain exclusion on the sale of a home can be used. If you would like to learn more about protecting the value of your home for the benefit of your heirs, please call our office and make an appointment to speak to one of our attorneys. Thanks for watching. And before you head out today, please remember to like our video, subscribe to our channel, and we look forward to seeing you back here in this space next week.